And I want to turn now, Madam Deputy Speaker, to the subject of courts and tribunals, which I touched upon earlier. Since 2010, government legal aid cuts have robbed thousands of the legal representation which should be their right. Many of them are those who are most in need of legal representation: people in debt, people claiming welfare benefits, people facing marital breakdown, and people facing housing problems. And those are just some examples. In 2012 to 13, 724,243 civil law cases were funded by legal aid. After the Legal Aid Sentencing and Punishment of Offenders Act, that figure plummeted. It plummeted to 258,460. Now, I do realise, Madam Deputy Speaker, that some on the benches opposite will toast these figures as evidence of a job well done. But in reality, what else is this but proof of access to justice denied? The coalition government introduced employment tribunal fees, and that measure resulted in a 70% reduction in the number of cases brought. And the long-delayed review that I mentioned earlier essentially concluded that there's nothing to see here. And it said, while there is clear evidence that ET fees have discouraged people from bringing claims, there is no conclusive evidence they have been prevented from doing so. Madam Deputy Speaker, if only illegal treatment by employers flouting the law of the land had reduced by 70%. But it's the number of cases that have reduced by 70%, not the number of instances of illegal treatments. I will give way.
Of giving way. I mean, isn't it the case that if someone gets something for nothing, it's likely they're going to take it up? And that was the core problem with employment tribunals, when people had to pay absolutely nothing to get access. It is right, if one goes to court, that one pays some kind of fee.
That's a very useful intervention, Madam Deputy Speaker, because it lays clear what the Conservative view on access to justice is. The idea of something for nothing. If somebody has not been paid the national minimum wage, why should they be charged to ensure that they get that money back? If someone hasn't been paid their proper wage, if somebody has been discriminated against on grounds of maternity, disability, or pregnancy-related discrimination, to say that these are people looking for something for nothing is outrageous. And it takes me back to the time when I was an employment lawyer, acting for these people that the Honourable Member dismisses in such a cavalier fashion. I remember the first time I lodged a case after the coalition government had introduced employment tribunal fees. I was lodging a case and it said on the Employment Tribunal Service website, "Customer, please enter your credit card details." And isn't that shameful that once we start looking at our citizens attempting to assert their statutory rights, whether it be the right for the minimum wage, the right not to be discriminated against at work, as soon as we primarily see them as consumers and not as citizens attempting to assert rights made in this place, then it shows the priorities of our society and our justice system have been warped by this government. I will do.
I'm grateful to him. Would he agree with me that part of the difference of opinion here, of course, is that some on the opposition benches apparently will overlook the fact that employment tribunals are very often brought by people who have no job. They have no income. That is why they are bringing a tribunal case. It's very different from a big commercial dispute when one pays court fees for access to justice to charge tribunal fees to people who have no income and no job, and that is the substance of their complaint to the tribunal.
Yeah. My honourable friend makes a very important point indeed. And another example that I would put forward is where people are being charged employment tribunal fees that exceed the underpayment of the wage about which they are complaining. So that really discourages claims. If your employer, I will give way.
But he's failing to mention that this was a policy which was designed in part to have more cases conciliated. And now, instead of 23,000 cases a year going to ACAS, 92,000 do, and half of them resolve. And of course, it's free.
the objective of the coalition government introducing employment tribunal fees was to strengthen the hand of employers, including unscrupulous employers, and weaken the hand of individual employees. And that's why it's a policy that, from the perspective of the government, has worked. That's what it was about. And as for ACAS conciliation, the ACAS conciliation offered now as compulsory conciliation isn't the same as the role of ACAS in the past when people had issued an employment tribunal case. There is no professional advice given on the value of the case, and just because a claim has been not issued or a matter has been discontinued doesn't mean it has been resolved satisfactorily with both parties on an equal footing. So to make it clear, Labour would abolish employment tribunal fees because Labour believes in access to justice. The honourable member shakes his head. He shakes his head, but the honourable member's comments earlier about people looking for something for nothing shows how out of touch that he is. So I will give way.
Opposite, I was suggesting that the honourable gentleman's policy is giving something for nothing.
More than implicit in the more than implicit in the honourable gentleman's ill-considered comments are the fact that to allow people to seek justice in the employment courts without paying money is a something-for-nothing practice. And I think that's a disgraceful comment, and we look forward to publicising it as widely as we can. The government needs to think again when it comes to employment tribunal fees. I will do.
But if we move from a system where very many cases go to the the employment tribunal to one where most cases are conciliated, what's wrong with that? It's a much easier way for people to get justice.
The problem is that the price that's being paid is the price of access to justice, and to us, at least on this side of the House, that's unacceptable. Is the government seriously contending that 70% of claims brought before 2013 were somehow fraudulent? Because if so, that's absolutely outrageous. I will do.
Can my friend repeat the figures? Because I thought he said in round terms that after these changes there were 500,000 fewer cases, and the minister has indicated that 70,000 more cases go to arbitration. That's a big gap. That's still over 400,000 people who aren't getting access to justice.
That's right, and the final point, that's completely right, and the final point I'll make on this subject before I move on to court and tribunal closures is that employment tribunal fees, the introduction of them, have harmed not only those who would bring a case, it's harmed those who would never dream of bringing a case. The reason being, if an employer knows that there's virtually no chance, if they break the law, of an employee bringing a case against them, it actually gives the green light to unscrupulous employers because they know that the risk is so much diminished of them being held to account. And this goes to the root of what access to justice is. Legal rights are basically worthless if you can't enforce them, if you can't rely upon them for reason of lack of resource or any other. On the subject